What is probate
Huh?
and when is it necessary? Probate is the legal process of transferring your assets after you've passed away to your beneficiaries. And this is usually through a probate court, which usually lasts 4 to 6 months, depending on your state. It could last longer. When is probate necessary? When there is assets that have your name on it. In other words, they're titled in your name. This could be real estate that is just titled in your name, a bank account, retirement accounts, life insurance policies. In all of those cases, you are most likely going to have to go through the probate process, inventory, show the court that these assets exist, that they belong to the deceased person, and then the personal representative will transfer them at the end of the probate after all the creditors and debts have been paid, everything has been administered. Then, and only at that time, the personal representative or executor will distribute those assets to those beneficiaries. Who is responsible for handling the deceased person's estate during the probate process? As you've probably heard about on TV and in the movies, there's always the executor or the personal representative, depending on where you live. They mean the same thing. But the personal representative takes an oath before the judge and swears that they will uphold the duties of executor. Part of those duties are to figure out what all the assets are in the estate, figure out what all the debts are, legitimate debts, get those paid, settle all accounts, and then, once that's done, distribute the assets either according to the last will and testament, or if there is none, according to that state's laws of intestate succession. How are the deceased person's assets distributed during the probate process? Like I've said in other videos, the distribution does not happen until the very end. The executor first has to figure out what all the assets are, settle all accounts, debts, creditors, and then and only then can they make a distribution pursuant to a judge's order. So how are they distributed? Well, it kind of depends on what the asset is. If it's real estate, then it might be a transfer of title to that beneficiary or beneficiaries. If it's a bank account, then that money may just be distributed as a check. A lot of times during probate, the real estate is sold, the money put into the bank account, and then cash is the only thing that gets distributed. So it depends on the estate. Can a deceased person's last will and testament be contested during the probate process? Absolutely. And that's one of the things that holds probates up more than anything else is either a son or daughter, it's usually the brothers and sisters who are fighting, have a disagreement over something in the probate, whether it's who gets what, whether the last will is valid or invalid. There can be a whole bunch of things, whether the personal representative is handling the estate correctly. Sometimes we have bad actors as personal representative or executors who don't necessarily know what they're doing because they're trying to do it themselves, and they end up doing, maybe through fault of their own, maybe through no fault of their own, embezzling money or spending money where they shouldn't have to. So there's a lot of ways to do that, and you do that by showing up at the courthouse, maybe filing a petition of some sort and contesting what is happening. So yes, it can happen. What are the fees associated with probate? Well, there are a lot of fees associated with probate. There's a filing fee that the courthouse is going to charge you just to start the probate. There are your attorney fees, and depending on your jurisdiction, that can be several thousands of dollars. There could be appraisal fees that need to get paid. You might need to hire an accountant to really get everything done on paper and figure out exactly what there is and where it's going to go to. So there can be a lot of fees associated. If you're going to sell real estate, there's going to be realtor fees. And then in that, there may be real estate appraisers as well, and maybe even a surveyor. So there are a lot of expenses that can happen during the probate process, and the executor, along with their attorney, is charged with handling all of that and paying it from the estate assets. Can the distribution of inherited property be delayed during the probate process? Distribution cannot be made until the very end. And a lot of times, heirs, beneficiaries, think that either the attorneys or the executor is delaying the process. But like I've said in other videos, the executor is charged with first figuring out what there is, second, making sure all the debts and creditors are settled, all accounts have been settled, and then and only then can they distribute the property. So that is usually what beneficiaries perceive as a delay, but it's really the executor just going through the process as they're supposed to do. There's a lot of legal, statutory timeframes that they have to wait until they can proceed to the next step. What is summary administration, and when can it be used in a probate? Well, a summary administration usually is when there is assets under a certain dollar amount. Then there is an expedited or expedited process to get the probate done quicker. However, sometimes that's not always the case, because in order to do it in most states, all the heirs have to consent to doing it in the quick manner. And sometimes, for whatever reason, one or two heirs will not do the consent, and it ends up taking just as long or longer than doing a regular probate. There's also, depending on how much money there is, it has to be under a certain amount in order, depending on your jurisdiction. And then usually if you want to sell real estate during a probate, you can't do a summary probate because usually the heirs are only determined at the end of the process instead of the beginning like it is in a regular probate. There are some drawbacks to it, but it can be done if all the puzzle pieces fit together. Can the distribution of inherited property be expedited through the use of a small estate affidavit? Again, it depends on the state that you live in, how much money we're talking about. And it usually is with money. You usually cannot use a small estate affidavit with real estate. But if it's a bank account under a certain amount, depending on your jurisdiction, it could be $20,000, $50,000, $100,000. I don't know. It depends where you live. The banks will sometimes allow you to use a small estate affidavit. I have seen lately that some financial institutions are not accepting those because they are afraid of heirs fighting or maybe not all the heirs being listed. So it is something that's available. I've seen it work usually when there's just like one or two heirs only, and we know for sure that that is the case. Can the distribution of inherited property be quicker if there is a revocable living trust? Usually the answer is yes. The successor trustee still has to perform a lot of the same duties that an executor has to do during a probate. They are charged with figuring out what all the assets are in the trust, and if the trust has been funded correctly, there's probably a pretty good inventory of all the assets that are already in the trust. Then they have to make sure that all the debts of the trust are paid and that no money is owed. And once they've completed that process, then they can make a distribution to the beneficiaries under the terms of the revocable living trust. And so that process, because there are not statutory deadlines or timeframes that have to be adhered to, can usually be a much quicker process. Can the distribution of inherited property be challenged in court? Absolutely. And that's probably one of the biggest fights that we see during the probate process, is that families are fighting over what they are going to receive. A lot of times they think they should have received more money. I guess nobody really fights about getting less money, right? That's usually the problem, is they don't believe that they are getting a fair share of the estate. The thing to remember here, that it was mom or dad's decision on what they wanted to give you. And it's not necessarily the fault of your brother and sister who you're fighting in the probate for extra money, especially if there's a last will and testament that say exactly what those distributions should be. That was a decision made by the person who passed away, not the person who you're trying to fight in court. But people fight all the time claiming undue influence, and that could sometimes be the case. But there are legitimate reasons where you might want to fight, especially if that undue influence created an invalid last will and testament. But in most cases, if it's all done correctly, then it's just a waste of time and money, in my opinion.
I know I've thrown a lot at you today, so that's why we prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that, so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.